So in those circumstances, we would say that we're not caught by the time limitation provisions in Schedule 5.
Well, it is. You're not doing what the contract envisages you will do, which is pay.
No, but we're offering something in lieu of payment,
which isn't effective unless it's accepted as in lieu of payment.
It's not effective as a payment, but it doesn't mean that the invoice is disputed, because what's implicit in set-off is that you are not disputing the validity of the invoice. You're simply setting off a cross-claim against it.
You're not accepting the existence of the amount due, but you are disputing the obligation which is envisaged by the invoice, which is to pay the sum within a certain time.
On its terms, yes,
Yeah.
but the set-off in my submission is apt to mean on the facts that one isn't disputing the invoice as such within the meaning of Schedule 5.
So what you're saying is, in fact, you can't dispute it under 1111.
There's nothing implicit in asserting a set-off that means that you're disputing the invoice.
I don't think that's quite an answer to my question. Are you saying that you cannot, that it would be incorrect to dispute an invoice on the ground of an equitable set-off under 1111?
Yes, because when you assert set-off, one isn't saying implicitly that the invoice is invalid or disputed. One is simply saying you have a cross-claim. So in a sense, it's implicit that you accept the validity of the invoice in that context.
Except here, CIS didn't accept the validity of the invoice. I mean, the judge rejected all of that, but I think there were a variety of reasons as to why it was said the invoice was invalid, which the judge rejected.
The judge said it was due in any event,
yes.
As at January 2017.
Yeah, no, I know that, but there were also what I might describe as technical points taken about the invoice,
yes,
which the judge rejected.
Yeah. I mean, it was the set-off was guarded that in any event we will assert the right of set-off without prejudice to all of the other points that we were making in terms of whether the invoice was due or not. But my point is there's nothing implicit in asserting a set-off that disputes the validity of the invoice. So therefore, the set-off as such is not caught by the dispute machinery in 11.
And is this right? There's no reference to set-off at all in these various bits of contractual machinery?
Don't believe so. No.
Because that in itself is quite unusual.
Yes.
Yeah.
Well, that brings me to issue 4. And issue 4 is this question, which is, has IBM discharged the burden of showing that Cisco's expenditure would not have been recouped and would have been wasted in any event? That formulation of the issue we have taken from Yam saying at paragraph 187, which I took the court to this morning.
Which paragraph?
187.
Thank you.
And if we could take my learned friend's skeleton, see the way the point is framed in the full bundle, tab 4, page 62. Paragraph 60. What is said is this, that the judge should have held that IBM had rebutted any presumption that Cisco would have recouped its investment through revenue or savings. That is because, quite independently of IBM's breach, the decision to sell Cisco to an acquirer who would take the business, the policies, and put them on their own system necessarily meant that the costs of the project would always have been wasted. And I'll take you to the evidence that they rely on in a moment. IBM must accept, in the light of cases such as Yan Seng, that the burden is on IBM to rebut the presumption referred to. They cannot seek to shift the burden onto Cisco, as there seems to be an attempt to do earlier in the preceding paragraphs of the IBM skeleton. Otherwise, we would be in a worse position than the claimant in Yan Seng or the plaintiff in Anglia TV. And if one looks at paragraph 60 of the skeleton, the words would always seek to do a lot of heavy lifting in this context. IBM's case must be that Cisco would not have recouped its expenditure on the project, even if IBM had fully performed and not repudiated the contract, i.e. the bad bargain hypothesis. However, the fundamental flaw here is that IBM conspicuously fails to refer to or to analyse the counterfactual that involves IBM performing the contract in accordance with its terms. What IBM seeks to rely on is the fact that following its repudiation of the contract, Cisco's parent company, the Co-op Group, decided to divest itself of capital-intensive businesses such as insurance and sold Cisco to another insurance group known as Market Study, expecting that the purchaser would take the business, the policies, and put them onto their own system, to quote IBM skeleton at paragraphs 57 and 58. Now, just for your Lordship's note, in fact, the sale to Market Study did not complete until December 2020, although it had been announced in January 2019. A lot of regulatory processes to be gone through. And IBM contends at paragraph 60 that it has therefore rebutted any presumption that Cisco would have recouped its expenditure on the project from additional revenue or savings, because the Co-op Group's decision to sell Cisco necessarily meant that the costs would always have been wasted. That's what's said. In other words, to put it crudely, the contracted for IT system would always have been jumped. And the first point is that this part of IBM's case should, in our submission, fail immediately because it wasn't pleaded or opened by IBM at the trial. IBM sought to...
Well, if it wasn't pleaded, it couldn't be opened.
It wasn't opened either.
No, if it wasn't pleaded, it couldn't be opened.
Indeed.
I mean, call me a traditionalist, but you plead something and then you have evidence by reference to the issues in the pleading, and then you open the case by reference to those issues.
Indeed.
So the starting point is you say it was not pleaded.
Wasn't pleaded.
So it must follow, if that's right, that there was no evidence
No.
on that issue.
No.
I mean, you said a little earlier that one of the problems is IBM don't analyse the counterfactual, but there wouldn't have been any evidence on the counterfactual because the point wasn't an issue.
Indeed. What IBM has sought to construct is a completely new case on causation. It's written closing. That's what happened. There was no oral closing, just so your Lordships are aware. And they try and construct it from a few stray bits of evidence going to unpleaded issues. And in the circumstances, the judge was justified in our submission in effectively disregarding the point, since it wasn't an issue properly before her. And in our submission, IBM's failure to raise causation as an issue in good time before the trial deprived the court of evidence on the issues raised by IBM's new causation case, specifically what would have happened if IBM had not repudiated, and what would have happened if IBM had performed its part of the contractual bargain. And for that reason, we say IBM should not be permitted to rely on causation on appeal.
I may have missed this. Did the judge just not say anything about it?
No. And in our submission, what IBM had to show is that if it had performed...
And that can't have been because she had reached the view that she did about the exclusion clause. Because notwithstanding the view that she reached on the exclusion clause, she spent ages, in tribute to the judge, dealing with what the figures would be if she was wrong.
Yeah, obviously we criticise the judgment in parts, but you certainly cannot criticise its diligence.
No, but you can't. I mean, on that particular aspect, the judge did what this court always encourages first instance judges to do, is to say, well, if I'm wrong about that, then the answer to the subsidiary question is why.
Yeah.
So we've got all the kit about, to the extent that the judge looked at the quantum in the latter part of the judgment and her views about experts and so on, all of which was irrelevant if she was right about the exclusion clause. So I'm just thinking out loud, really, that can't be the reason so that she didn't deal with this. So you say the reason she didn't deal with this is because it wasn't an issue.
It wasn't an issue.
And she certainly, the parties had certainly given her enough of the exam paper as it was.
Yeah, and what in terms of the material she didn't have was any evidence on the relevant counterfactual. What the counterfactual as to what would have happened if IBM had actually performed the contract, and what the co-op group and what Cisco would have done in those circumstances. IBM would have to have shown that Cisco's parent company, the co-op group, would still have acted in the way that it did in December 2020 following the failure of the project in mid-2017, i.e. by selling Cisco to another group, which would have had no use for its IT system. None of that was explored in evidence. There's a stray bit of cross-examination which is effectively relied on by IBM as the entire building block of this case, unpleaded as it was.
And there's still no application to amend.
Not that I'm aware of.
Was there a list of issues at trial?
I'm sure there was. Yes, I don't think this was included on it. Yes, the judge sets it out. I'll give you the reference in a moment. So what IBM ought to have been able to demonstrate was that what they refer to in paragraph 60 would always have happened even with the benefit of full implementation of the project by IBM. And what that requires is consideration of what would have happened in a totally different factual situation, which was simply not addressed in the pleadings, in the witness statements, in any expert reports, in any disclosure, in the openings and closings at trial, the judgment, or even in IBM's appeal stint. The relevant counterfactual is one in which IBM not only refrained from repudiating the contract, but also fully performed it.
The issues the judge sets out in paragraph 191.
Yes, that's the reference I've just been given.
Issue 5, quantum, obviously doesn't include this issue, but I was just asking, is that list there the one that was settled or prepared? Or?
I don't know whether it's the... I obviously wasn't present at trial. I'll just... If you're looking for the distillation. I'm told that there was an agreed list, but that is the judge's...
that's her distillation of what was before her.
That's her distillation of the list. As I said, the relevant counterfactual is one on which IBM fully performed the contract. Otherwise, IBM cannot establish that Cisco struck a bad bargain so that its wasted expenditure would always have been wasted. And if we were going to attempt that exercise now, and the court has our submissions that it's far too late, we would first have to construct the appropriate counterfactual with some care. The question of what the co-op group would have done with Cisco if IBM had not repudiated was not properly explored in the evidence at trial. If the contract had been fully performed, Cisco would, during 2016, have had a flexible modern IT system which, referring to the judgment at paragraph 3, was intended to enable it to provide tailored services to its customers and to compete as a market-leading digital and database business. That was the aim identified by the judge, and that is an underpinning of the relevant counterfactual that would have had to be explored. What this arose from originally, if we take this in stages, is there was a witness statement from Mr. Summerfield, the CEO of Cisco, in the supplemental. It's in the supplemental bundle behind tab 11. Page 140. And hopefully the court should have paragraph 6 there of Mr. Summerfield's statement of the 12th of July 2019. Paragraph 6 in the fifth line from the end, he said Cisco was originally going to be sold, but in early 2014 the co-op group took the decision to retain it. I was tasked with turning round the general insurance business. In January 2019, the co-op group announced its intention to sell Cisco to the market study group. At the time of making this witness statement, the transaction is still in progress. But that's where it started. And in terms of the oral evidence, the only point at which the counterfactual, as it were, was explored was in re-examination, after some questions which I'll come back to in a second by Mr. Tozzi. If one goes, please, to tab 15 in the same bundle. See an extract from Mr. Summerfield's re-examination.
Sorry, I need the page number.
Page 160, I'm sorry. And at page 160 at line 5, see what Mr. Charlton asks is, had IBM performed under the MSA, what would have been the position, do you know? An answer, we would have had if the business case had been delivered, we would have had a more profitable business, but I think my recollection of the business case numbers that presented earlier on in evidence was that we're producing a 3 to 4 million a year profit. The group would have either chosen to keep the business, because they would have had that 4 to 5 million a year profit, or would have divested it for a significantly larger sum. And I would add to that Cisco would also have had the benefit and would have been locked into a £125 million 10-year managed service agreement with IBM if the contract had been performed. And if we look at the cross-examination of Mr. Summerfield that is relied on by IBM, we go back to the previous tab 14 at page 141. Page 151, Mr. Summerfield is asked, so I come back to my suggestion, the decision not to proceed with the business transformation involving an IT re-platforming solution was because of the new commercial situation which came about as a result of the board's decision to sell Cisco. Answer, yes, in 2018 the owner, the parent, the group board made a decision to divest Cisco. At that point in time you no longer need a platform. Question, and that is why, isn't it, once that decision had been made, probably in about February 2018 so far as we could tell, that is why you then reverted to as is, because you are, to use a word we've seen in a different context, slightly in a state of limbo until the sale to market study is completed. Answer, you wouldn't invest in a new platform if you intend to sell a business, and your expectation was that the acquirer would have a pre-existing platform. In fact, you would be diminishing the asset. And it's that part from line 19 that's quoted by IBM. So Mr. Summerfield goes on to say, we reverted to as is at the point that IBM terminated the contract because we didn't have any choice. And we continue to invest in as is in the meantime in order to keep it within our risk appetite and broadly comply, i.e. comply with the regulatory environment as we could. So what was never explored with Mr. Summerfield was whether the same decision would have been made if IBM had delivered as per the contract in 2016. That was only explored, as we've seen very briefly, in re-examination. And we saw from Mr. Summerfield's witness statement that he was brought in to turn around the general insurance business in 2014 after the co-op group had decided to retain it, and a brand new IT platform was part of that process. So even assuming that the co-op group's preference would still have been to sell Cisco with a new IT platform delivered by IBM, that is a very different scenario to that actually prevailing in 2019. In 2020, there is no reason to think that the purchaser, which in those circumstances, my lords, might not have been market study, would have wanted to abandon the new operational and profit-generating IT system. As I say, with the benefit of a 10-year service contract, managed service contract with IBM. Indeed, my lords, there is every likelihood that a purchaser, perhaps a new entrant to the market, would have wanted to retain the system and or perhaps transfer any existing insurance business to the IBM system, rather than the other way around as market study sought to do. IBM simply assumes that because market study in the event put Cisco's insurance business onto its own IT system after buying Cisco with its creaky old system, so a buyer, whether market study or anyone else, would inevitably have done the same thing in circumstances where Cisco was using a brand new market-leading IT system with the benefit of a 10-year management contract with IBM. And in our respectful submission, that assumption only needs to be stated to be rejected. And even if Co-op Group had still sold in 2020, if the relevant counterfactual is that IBM delivered the system in 2016, Cisco would have had the benefit of the new platform for some 3 to 4 years, i.e. the intervening period from 2016 onwards. And my lords, even if IBM now argues that the relevant counterfactual is one in which the facts are assumed to be exactly the same as actually occurred, except for IBM's repudiation, IBM's position at the point of termination is that the project could still have been delivered. That's their skeleton, paragraph 7. If that is so, and it was not explored in any detail at trial, the circumstances would still have been radically different from those that existed following IBM's repudiation of the contract, and the consequences of that were also not explored. In particular, the parties would have been bound both to continue implementing the IT system and thereafter to operate it under the 10-year managed service SAL. It cannot be assumed, as IBM implicitly does, that either or both parties would in those circumstances have acted in the same way as they did after the contract had been terminated by Cisco's acceptance of IBM's repudiation in 2017. My lords, it follows that even if IBM is to be permitted to run its causation case, it cannot discharge the burden of proving that the system would have been junked in any event, particularly in the very different circumstances that would have existed if the project had been successfully implemented in accordance with its terms, and oblique or if IBM had not repudiated. My lords, IBM has asked for its reply and defence to counterclaim and a couple of letters between the parties' solicitors to be included in the bundle, and it may seek to rely on those. I'm not sure to what effect. They aren't adverted to in the IBM skeletons, and we'll address any points on those documents in reply, if they're made. Unless your lordships have any questions, those are my submissions on issue 4. And the main problem with trying to run this point now is that there was no exploration of the relevant course of action at trial.
Yeah.
My lord, issue 5 is the damages caps under clause 23.5. As I said, it's a relatively short point of construction. Our skeleton at paragraph 41 explains why we submit it's appropriate for the Court of Appeal to deal with this issue, and that doesn't appear to be controversial. In a nutshell, this is
Well,
the point.
well, the parties can agree it. Whether the court agrees it will obviously depend on the material. As I indicated at the start, we'd be very anxious to if we could, but that's the point where we would reserve the right to
Absolutely,
say,
I accept that, and for these purposes I do not need to refer to anything outside the four corners of the contract.
Well, sorry, I don't wish to interrupt. Just for the point of clarity, I quite accept that the point of construction can probably be determined by this court. There may be a factual issue, though, and that may be more difficult.
All right. Well, what we're very happy to do is to consider all the submissions, and our predisposition is to try and deal with everything. But if there is a point that we legitimately hold our hands up and say, I'm sorry, we can't deal with that on the basis of the material we've got, then obviously we'll have to say so. But everybody must make all of the submissions they want, and then we'll consider it. But
yeah, I certainly didn't mean to imply that the court was bound by the parties' agreement.
No.
And your lordship indeed reserved the point as to whether it would be appropriate for the court to determine it in the order, the directions order you
Did I?
Yes.
I mean, that was far-sighted. It's a very rare event. All right, let's go to the. You say by the four corners of the agreement.
Four corners of the agreement.
So is that where you want us to start?
That's where we should start in the supplemental bundle.
Yep.
Supplementary bundle at tab 1. I should just say, in the light of what Melinda French just said, that there isn't a factual issue identified in the skeleton, so I'm not sure what it is.
All right. Well, let's see how we go. Yeah.
So we can see the relevant clause at page 41, same place we were at before. It's 23.5 at page 41 behind tab 1 of the supplemental bundle.
Yeah.
And the particular clauses that will be engaged in this discussion are subparagraph 23.5a and 23.5e. And the question is whether, if Cisco is entitled to recover its wasted expenditure, its recovery is capped at 99.163 million by aggregating the caps provided at clause 23.5a and clause 23.5e1 as we submit, or is its recovery capped at 83.463 million by the cap at 23.5a alone, as IBM now says. And the issue here has narrowed since the trial, and indeed since we served our initial skeleton, because IBM no longer contends for a still lower cap for which it argued at trial. So those are the choices. And obviously, in either case, those caps come in significantly below the 122.6 million in wasted costs that the learned judge found.
And are those the figures without taking into account effectively the set-off
Those are figures without taking into account. So
The IBM's right to set off the 2.89 million under the invoice.
So the 2.9 million would need to be deducted from those figures.
Yeah.
I think that's common ground.
Okay.
So going back to clause 23.5, you'll see that 23.5 A refers to IBM's liability to Cisco for the implementation services shall be limited to, etc. So 23.5A is relates to the cap for implementation services. This court has seen that had a separate statement of work. And that figure, the relevant figure there, is, as I said a moment ago, agreed at some 83.4 million. And just so your lordships are aware, the only part of clause 23.5 which addresses the managed services is 23.5e. You can see that explicitly from subparagraph little Roman 2, which refers in the second line to managed services. But as I will come to in a second, subparagraph little Roman 1 is also calculated by reference to the charges payable for the managed services, the 15.7 million.
Yeah.
So 23.5A, the cap under that provision is common ground if we're right on the prior issues. Just so your lordship is aware, subparagraph D, there were in fact no program-related or additional service SOWs. So D doesn't arise for consideration. B refers to the indemnity at clause 24.1, which you see at page 43, which relates to data protection. So that's capped at 5 million.
But we're not concerned with that.
We're not. I just want to map out what the clause deals with, because it may be relevant. And C deals with regulatory fines, which you see dealt with paragraph 24.2, page 44, which deals with fines levied by the PRA or the FCA, and that's capped at 3 million. So the liability under subparagraph E1, 15.7 million, IBM's liability to Cisco arising otherwise under or in connection with this agreement shall be limited to the greater of, and the figure of 15.7 million at E1 is agreed to be the relevant one in E1. Now, before going to the rival constructions, it's worth noting that, as I said at the outset, there were just 2 statements of work made under the MSA. And as I said at the outset, the MSA was effectively a standardised set of terms governing the detailed services set out in the statements of work. On its own, the MSA didn't oblige IBM to carry out any particular work. And it didn't oblige Cisco to pay anything. That was the function of the statements of work. And if we go first to the same bundle to the implementation services cell, behind tab 7, beginning at page 105.
Yeah.
And if one goes to clause 5.1 at page 113,
Yeah.
Paragraph 5.1.1.1, you see in the middle of the page the total charges associated with this SAL are some 50 million odd. And so the first cap in 23.5a is calculated at 150% of that amount. Plus. It's actually slightly more complicated than that because there is a preceding obligation which isn't in the bundle, but the figure of 83 million is agreed as being the relevant figure.
Okay.
So I should have worked that out myself. And then if we go to the managed services SAL, the next tab beginning at page 124, and if we go to page 128, we'll see how the price is made up. But paragraph 4.2, see the fixed price components at the bottom of the page in 4.2.1 amounting to 100 million plus, right at the bottom of the page. And then over the page at 4.2.3, capacity priced components not exceeding 25 million odd.
Yeah.
So those are where the underlying figures derive from. And if we go back against that background to 23.5, page 41, the cap at, page 42, the cap at 23.5e is the higher of 15.7 million or 125% in subparagraph 2. And as I said a moment ago, the second cap is explicitly calculated by reference to managed services, but the first cap at subparagraph 1 is also based on a year's charges for the managed services, because it is 125% of the average annual charge for managed services. And we set out the calculation, don't need to take you to it, but the calculation is set out in our skeleton, paragraph 52 at footnote 10. Reference, core bundle, tab 2, page.
Sorry, I'll need to just follow that. So skeleton page.
It's page 29 of the core bundle.
Yeah.
If you look at the footnote to page 29, footnote 10, you see where the 15 million figure is derived from. They're
So
not
it's-
randomly plucked out of there.
So it's the divider 10, that's the number of years it was
The managed service.
anticipated to run, and then it's 125% of that yearly charge.
Indeed.
Yeah. Annual charge.
So one can see, going back to supplemental bundle at page 41, that the first cap at A is based on the amount payable to IBM for the implementation services. That isn't in dispute. The second cap at E is based on the annual amount payable to IBM for the managed services. So we can
Although
see...
you get that, as you say, from the reference in E(2) and the calculation you've just taken us to.
Indeed.
It doesn't say so with the clarity that one might have hoped at the beginning of E.
Yes, I would accept that.
Yeah.
But one can deduct by
Yeah.
the process that E is effectively dealing with managed services.
Is that because that is the only thing left?
after you take into account A, B and C. So IBM's liability for the implementation services under A, subject to the other issues, is agreed. What is disputed is whether IBM's liability also arises otherwise under or in connection with the agreement under E. And IBM says that the word otherwise means that E is mutually exclusive of liability under any other subclause. And in our submission, that is wrong. Otherwise simply means liability arising otherwise than in relation to the services described, or the liabilities described, in A, B, C, and the non-existent D. And that is supported by the opening words of 23.5, which refer to aggregate liability. The dictionary meaning of aggregate as an adjective is formed or calculated by the combination of several separate elements. And the last words of clause 23.5, just under letter F, those two lines, also in our submission make clear that the caps were intended to be cumulative in principle.
Which word, sorry?
The words beginning, the provisions in this clause 23.5 shall operate as separate and additional liability limitations to all other limitations of liability in this clause 23.5. Which is in line with the opening words of 23.5, referring to aggregate liabilities. And we say both caps apply cumulatively because IBM's liability is both for the implementation services under A and, secondly, arising otherwise under or in connection with the agreement under E, i.e. for the managed services. There is no other place where managed services are dealt with other than in relation to E. Now what IBM says is that the cap, this is skeleton paragraph 68, that the cap is governed by IBM's liability for the claim that is brought, and they say that's wrongful termination of the MSA, not by the identity of the SAL or SALs affected. And in our submission that makes no sense because the MSA was just a set of floating terms which were captured by and incorporated into each SAL. The MSA gave Cisco and IBM nothing meaningful on its own. All the services, the payments, they are all the subject matter of the SALs. The detailed services are spelt out in each statement of work. And what was terminated was a single contract comprising both SALs and the MSA. And if you keep a finger in there, just remind the court, if we go on to page 59 in the same bundle, one sees the definition of agreement on page 59, at the foot of page 59. The agreement is defined as including each SAL. The MSA and both SALs were signed simultaneously as a set and were inseparably linked. None of the three documents would have been signed without the other two. You can see that from the references in the MSA. So as a matter of analysis, there was one contract under which IBM agreed to implement the IT system and to manage it for 10 years. IBM's purported termination by letter on the 27th of July 2017 made clear that no further services would be provided under either SAL, and we set out the relevant parts of the 27th July termination letter paragraph 49 of our first skeleton. So when IBM repudiated on that date, it repudiated the entire contract, thereby depriving Cisco of the benefit of both the implementation and management of the IT system. And at common law, without any exclusion or capital liability, Cisco would have been entitled to recover damages based on its loss of the entirety of the contract. So if Cisco had to pay, for example, another supplier more money to implement a substitute system and more thereafter to manage it than it had to pay IBM, be entitled in principle to recover both additional amounts from IBM. Cisco will be recovering compensation both for the loss of the implementation services and for loss of the managed services, or in the contractual language in respect of liability for the implementation services, and also arising otherwise or in connection with this agreement, where the agreement is defined to include both sounds. As I say, the cap on liability in relation to the implementation services is only found in one place, and the cap in relation to liability on the managed services is only found in one place. The fact that the claim is for wasted expenditure makes no difference to that analysis. Cisco incurred all its expenditure in reliance on IBM's obligation to provide both the implementation and the management services, because this was a contract to implement and to manage the IT system, and the totality of Cisco's costs were incurred in reliance on and in anticipation of both sets of IBM's obligations.
So on that basis, you say there's no requirement on the part of Cisco to differentiate between the implementation contract and the managed services contract.
Our ability to recover is capped cumulatively in two respects, is the way I put it. The aggregate liability within the meaning of 23.5 encompasses both the liability, capital liability in relation to the implementation services and the managed services. Hence the opening words of 23.5. And both of those figures come in under the 122 million odd that the judge found that we had wasted in reliance on the contract.
Can you say, as night follows day, every piece of expenditure that you incurred was incurred in anticipation of both and not one or the other?
Yes, because what we contracted for was a package. If you take one agreement, including the master services agreement and the two statements of work, what we were buying, in effect, was the implementation of the system and then its management for a 10-year period. So yes, is my answer to your Lordship's question. It's not possible to differentiate.
One could differentiate. I mean, one can posit things which would differentiate. So you might have taken steps to prepare for the fact that this was going to be managed over the following 10 years by perhaps employing somebody who would then be supervising their role, something like that. That particular expenditure would relate only to the managed services.
If it's possible to differentiate, I guess that's theoretically possible, but it isn't. I mean, for example, a lot of the wasted expenditure was in relation to funding of the project. And it's very hard to say, well, part of that was in relation to management services and part of that was in relation to the implementation services. What we bought, in effect, was a package, and one wouldn't have been bought without the other. What we wanted was a new IT system, which would be managed.
There was no exploration at trial, was there, of whether any part of your expenditure did relate only to one bit or the other?
No, and this was one point the judge didn't decide in terms of which cap applied where.
But if it wasn't explored in the evidence, again, you can't...
Well, in my submission, there was no need to, because our wasted expenditure exceeds both caps, and the expenditure was effectively spent in anticipation of both sets of the obligation. We wouldn't have contracted for one without the other, because it's one composite agreement as defined. Well, unless I can assist you further, those are my submissions.
No, thank you very much, Mr. Thankey, and you're 35 minutes ahead of schedule. So, thank you. Yes, Mr. Tozzi.
Lord, can I say I'm going to follow the 5 main headings identified by my lone friend in the same order as him, so hopefully you'll know where I am at any particular moment in time. My Lord, as far as the first main ground of appeal is concerned, subject to the court's agreement, what I want to do is to make general submissions regarding that point, but I then want to invite my learned friend Mr. Kramer to make some submissions in relation to the academic texts, particularly Professor Peel's, to which you've been referred, before I then resume to deal with the 4 remaining issues. So, I hope that will meet.
Yes, that's fine.
So, can I start then with the main ground of appeal? And I want to say something, first of all, about the damages claimed by Cisco in this case, and how that claim fits into the law's approach to damages for breach of contract. And to do that, can we start, please, by looking at the amended particulars of claim, which are in the core bundle behind tab 13 at page 281. Sorry, they start at page 270, but I'm going straight away to page 281. Just to remind your lordships of how the claim was put. You'll see at paragraphs 34 continuing through to 37, what was pleaded was, and indeed the claim on which Cisco succeeded, was that there was a renunciation and a repudiatory breach. As your lordships are aware, the judge held that IBM's termination notice was invalid because Cisco had disputed the invoice for application gate 5, a point which I'll return to when we come to the respondent's notice. It is, we would submit, trite law that damages for loss of a bargain are intended to put the innocent party in the position it would have been in but for the breach. But it is important, properly we say, to understand the nature of the damages claimed, noting, as we do, the acceptance by Cisco, and you see this in their skeleton at paragraph 34, that a claim for loss of profits has the same juridical basis as a claim for wasted expenditure as a form of expectation loss. Now that's an important acceptance of the position by Cisco, to which I will return. But my lords, just as you've got open the amended particulars of claim, I took you to 281, which was the pleading of the renunciation and the repudiatory breach. If you could then turn forward to page 290, you'll see that the sums that were claimed as the waste, which became the wasted expenditure claim, it was pleaded at 132, as we've heard the judge allowed 122. They included various items you'll see incurred pre-MSA, post-MSA, sums incurred with third-party suppliers, and so on. Cost of revising IT processes, cost of a 3-year contract for Trek printing, sums incurred with third-party suppliers post-termination, finance, but committed before termination, finance costs, management expenses, and secondees, unless some adjustments and so on. So, my lord, that was the breakdown of the expenditure on which the judge, we spent some time at the trial itself looking at those individual items. Now, my lord, if we can then turn, please, to the judgment, which in paragraph 670 to 672, and that is in the supplemental bundle behind tab 7, page 240.
I mean, I assume that, I'm sure we don't need to see it, but I'm assuming that this one-page table was further particularised.
Yes,
In terms, I mean, there would have been dread word, some form of Scotch schedule setting out some form of
yes,
detail. I mean, I imagine somebody would have wanted particulars of this, given the sums involved.
particulars were sought. I don't think there was a Scotch schedule.
Well, that's always a good thing.
Yes, indeed.
But there must have been some form of
There was.
expanded version of this. I'm not saying that we need to see it. I'm just sort of looking at this.
A lot of it was dealt with through forensic accountancy reports. Yes.
Yeah. Well, and the judge refers to that.
Yeah, and
Okay.
that was the main. There was evidence from witnesses of fact as well.
Yeah.
But
Okay. So then we come to 6.
So, my lord, I was going
want
to
us
take
to
you
look
to
to
the judgment. Yes, it says, sorry, I gave you the wrong reference. It's in the core bundle.
Yeah.
It's tab 7, and I want to look at page 240.
Yeah.
Please. I want to pick up the judgment at 670, which is how the judge then approached the damages claim. And she said, and my learned friends referred you to it, but I just want to remind you of it, a fundamental principle of the common law relating to damages for breach of contract is that they are compensatory, and she set out the established rule from Robinson and Harman. They should reflect the value of the contractual bargain, and she set out an extract of the judgment of, the speech of Lord Scott, Golden Strait and so on, and she then reaffirmed, or referred to the rules being reaffirmed by Lord Reed in Morris Garner. And we say that's a correct analysis of damages for breach of contract. That is the basis on which the judge approached Cisco's claim, and she cannot be faulted for that. The touchstone in all of these cases is compensation based on the expectation of what the position would have been after the contract had been performed. And that's, we'll come back to that, expectation loss and what actually amounts to expectation loss as compared, for example, to say reliance loss, which is an important distinction that I want to come back to. At 681 of the judgment, or page 244, the judge looked at the losses with which we are concerned. She said at 680, the starting point is to identify the contractual benefit as a result of IBM's repudiatory breach of contract. Cisco's business was the underwriting and distribution of general insurance products. The new IT solution was anticipated to improve Cisco's competitiveness as a market-leading digital and database business, which would produce substantial savings, increase revenues, and increased profits. The loss of the bargain suffered by Cisco as a result of IBM's repudiatory breach comprised the savings, revenues, and profits that would have been achieved had the IT solution been successfully implemented. And those are important findings of fact on which there was plenty of evidence before the judge. And she went on at 683 to note that a conventional claim for damages in this type of commercial case would usually be quantified on the basis of those lost savings, revenues, and profits. And then she said this: Cisco is entitled to frame its claim as one for wasted expenditure, but that simply represents a different method of quantifying the loss of bargain. It doesn't change the characteristics of the losses for which compensation is sought. And we say, and we'll look at OMAC and some of the other cases in more detail, that that is an absolutely correct characterisation of the position. Indeed, if one thinks about Cisco's expectations a little more carefully, effectively, they fall into two baskets. First, decrease costs through anticipated savings, which Cisco would have had but for the termination of the repudiation. Secondly, increased revenue from an increase in the premiums, which Cisco forecast would have been achieved. And my Lord, is not before your Lordships, but there were, as you can imagine, all sorts of papers and analyses carried out by Cisco before they entered into the contract showing what they thought they were going to get from this bargain. If and when those savings and the increased premium, or the increased revenues, equaled the costs that Cisco had to incur to install and run the new IT solution, then any excess over that sum would become Cisco's profit from the contract. So it only actually gets a profit once it's recouped its expenditure through the anticipated savings and through the increased revenues. Indeed, another accountancy sort of way of looking at it would be to say that the IT solution is going to produce increased revenue and savings in a credit column, but the costs incurred on payments to IBM and others go into a debit column, and the lost profit is the amount by which the credit would have exceeded the debit, if one ever got to that point. Now, following, so that is why when one talks about wasted expenditure, it's important to understand that it's about recouping the expenditure, which we'll come back to. Now, coming back to Robinson and Harman, the damages which are recoverable for a breach of contract in a case such as the present are of course not limited to lost revenue or missed savings. Those recoverable damages can also extend to any additional costs which have been incurred, which would not have been incurred but for the breach. And that, most obviously in this case, would have included the costs of procuring a replacement solution, so-called costs of cure. Such reprocurement costs are, of course, recoverable and will often reduce or even avoid other consequential losses of revenue or savings which the innocent party might suffer. But there is a fundamental difference between costs which would have been incurred in any event as a result of entering into the contract, and which i.e. so-called wasted expenditure, and costs incurred as a result of the breach, in other words, costs of reprocurement or cure. They are fundamentally different. And as Cisco itself asserts, it's in their skeleton, paragraph 36, which is in the core at page 23, this reprocurement costs is the paradigm type of loss in a failed IT solution case. And importantly, in our case, the contract provides expressly for the recovery of such costs in clause 23.4. We'll look at that clause in a moment. And the only reason we're having to consider an alternative claim, a claim based on wasted expenditure, is because a claim for reprocurement costs, in other words, getting another system instead of the one that IBM had agreed to install, those costs were not incurred because they decided that they didn't want to do that. And when we look at the fourth main issue, I'll take you to some of the evidence, a bit more of the evidence than my learned friend took you to, given by Cisco's Chief Executive Officer, Mr. Summerfield, from which you'll see that a claim for the cost of cure was not made effectively because Cisco's parent, the Co-op Group, decided that it no longer wanted to invest in capital-intensive businesses, and it decided to sell Cisco to a buyer which had its own IT platform. So the short explanation for the claim being put as it was, and now is that Cisco no longer wanted a new IT solution. And finally, just to complete the picture in terms of the claims that were made or could be made, Cisco also advanced an alternative claim for additional resource and third-party costs arising from delay, which we always accepted was not excluded and of course resulted in the judgment which Cisco did obtain for 15.9 million, subject to IBM's set-off of 2.9 million. So, if we come back to the wasted expenditure claim, as I've shown your lordship how that was put in the amended particulars of claim, and the judge found, and again it's common ground I think between us, that the Cisco had actually incurred costs on the project of 122.6 million, and she deals with that at some length in her judgment. We don't need to look at the detail of that. Those sums were incurred to fund the construction and the installation of the new IT solution. They are all sums which Cisco would have incurred if the contract had been fully performed. So, applying Robinson and Harmon, none of those sums are recoverable in their own right. And the position in contract can and should be distinguished to the approach which the court takes to damages in, for example, tort, which aims to put the innocent party in the position it would have been in if the tort had not occurred. So, can I then turn to the law on wasted expenditure, because that is the background against which we need to consider the basis on which wasted expenditure can, in certain situations, be recoverable for breach of contract. And to do that, I want to start with the judgment of Mr. Justice Tier in OMAC. As your lordships have seen, the judgment which was subsequently described by Mr. Justice Leggett, as he then was, as masterly, and a judgment which Professor Burrows, as he then was, has described as, and I quote, it's in the footnote to the passage you were taken to earlier by my learned friend, the most important case clarifying the correct understanding of reliance damage. The lordships can find that in the authorities bundle, tab 24, page 702.
Because of the heresy that reliance damage, I think, started by an academic, reliance damage wasn't properly compensatory.
Your lordship is already ahead of me.
So I mean, that is why AMAC is important.
Yes.
I mean, it's obviously important for a number of reasons, but as I understand it, that's why it quite rightly has garnered the accolades that it's got.
And the heresy is one which my learned friend skirts round and every now and then dips into, but without ever making a full frontal assault on OMAC so as to say it's wrong. But you will see, and I'll show you passages in his skeleton in due course, examples of where he is effectively treating reliance loss as if it was a separate compensatory form of damages for breach of contract. The exact heresy that OMAC attacked. Can we go back to, I know my learned friend took you to it, but there are a number of bits in the judgment that he didn't read to your lordships, and I think it's quite important that we should look at it in some detail. My lords, it's in the authorities bundle behind tab 16. And I don't need to look at the head note. My learned friend read that to your lordships.
I don't have the
Oh, I'm so
readily,
sorry. Yes, I'm so sorry. It's page, well, in our bundles, it's page 453. I think, your lordship, that may mean it's 454 or 455.
Yes, basically in my version, the index is also paginated, so it's 2 pages on. You give me the number that's on the hard copy, and I'll work it out.
Yes, my lord, I'm so sorry that that's happened.
Don't worry.
It's dementing.
Happens a lot.
So, my lords, my learned friend read from the head note. I don't need to go to that. But if we turn to paragraph 4, again, I don't need to read it, but in due course, if your lordships go back to it, you'll see in paragraph 4 quite a helpful summary given by the judge based on what Mr. Brenton had said of the facts as found by the tribunal. We can skip over that, but can we go, please, to paragraphs, pick it up at paragraph 9, which in those of us on hard copy of 457, so I imagine your lordship is 459, because it's important, I think, to understand the opposing arguments. So paragraph 9 was the argument by Mr. Young. He was challenging the tribunal's decision, and his arguments prevailed in front of Mr. Justice Tier. And I don't need to worry about the detail of those, but can we look at what Mr. Brenton was submitting? Because it's Mr. Brenton's arguments that are of the most interest to us. Paragraph 10, Mr. Brenton submitted that the tribunal's decision was right in law. His argument was perhaps not as simple, but was nevertheless principled. Where the law protects a party's negative or reliance interest, as where wasted expenditure is claimed, the benefit flowing from the substitute employment cannot be taken into account to reduce or extinguish a claim for wasted expenditure. Robinson and Harman does not require that benefit to be taken into account, since it is concerned with the protection of the party's positive or expectation interest. It's only when the law is protecting that interest that it is appropriate to compare a party's actual position with the position had the contract been performed. Robinson and Harman does not provide a rational and sensible explanation for the award of damages in a wasted expenditure case. Mr. Brenton accepted the principle in British Westinghouse and applied and so on, but submitted that properly applied, it did not prevent the claimant from recovering expenditure wasted as a result of the breach of contract. By entering into the charter party, the owners not only committed themselves to expenditure which was wasted by the charter's breach, but also gave up the opportunity to charter the vessel at market rate. The sacrifice was also wasted by the breach, and so on. I won't bother reading to the end. And then that's followed by a discussion, which again, I don't think my learned friend read to you, but I think is quite important. So Mr. Justice Tier starts with Robinson and Harman, and he, like many others before and after him, refers to the celebrated and short passage of Baron Park, and he sets that out. And at 12, he says this: it's to be noted that the plaintiff claimed both expenses incurred in reliance on the contract and damages for loss of bargain. There is no discussion as to how the expenses were taken into account when calculating the damages, but in the light of Baron Park's principle, it's to be inferred the plaintiff did not end up in a better position than he would have been had the contract been performed. And then he says that that principle was restated in Wertheim and recently said to be a fundamental principle governing quantum of damages, Golden Strait, and so on. My lord, at 15, he explained how in a typical claim for damages for breach of contract on the expectancy basis, both expected profits and necessary expenses will be taken into account. The claimant will claim a sum equal to the benefit he expected to earn from the performance of the contract, less the costs he would have had to have incurred in order to earn that benefit, which costs would include not only any sum he would have had to pay to the party in breach, but also any expenses he would have had to incur in preparation for the performance of the contract. So our case. Damages calculated in that way will put the claimant in the position he would have been in had the contract been performed. The measure of loss thus compensates for the loss of bargain, and in doing so takes account of the expenses the claimant would have incurred in reliance on the contract being performed. To ignore those expenses when assessing damages would put the claimant in a better position. Equally, if those expenses had already been incurred, the date on which the contract was repudiated, to award those expenses in addition to damages for loss of bargain would put the claimant in a better position, and so on. My lords, can we then move forward to, and he considered that, that's the mitigation point. Can we move forward though to paragraph 19, which is on our hard copy, page 460, where he then considers the so-called reliance basis. He said this: the law of damages permits a claimant to seek damages on the reliance basis rather than upon the expectancy basis. He may elect to claim damages by reference to the expenses incurred by him in reliance on the contract being performed. See Cullinane and Anglia TV. In the present case, the claimants, having abandoned their claim to damages on the expectancy basis, claimed damages in the sum of the expenses incurred, and so on. There's no dispute that damages may be claimed on that basis, but the question raised by Mr. Brenton's submission is whether, and if so how, the principle in Robinson and Harman applies so as to ensure that the claimants are not put in a better position than they would have been had the contract been performed. there is considerable authority both in other common law jurisdictions and in this jurisdiction for the proposition that the recovery of damages on a reliance basis is governed by Baron Park's principle in Robinson and Harman. Given the fundamental nature of that principle, that is not surprising. Now, my lords, at paragraphs 22 through to 34, Mr. Justice Tier then considered various authorities, including the decision of Chief Justice Learned Hand in Armstrong Rubber, including the leading Canadian case of Boley logging and the leading Australian case of Amended. And my lords, rather than my reading it to you, can I invite you, if not now, but in due course, just to read those passages from the judgment, because they explain where Mr. Justice Tier then got to when we get to paragraph 35, which is where I next want to go to.
Okay.
Paragraph 35, which is in the hard copy, is page 464. Says this: Mr. Brenton accepts, as he must, in the light of the above authorities, that there are authorities which seek to explain reliance loss as a species of expectation loss, but he submits that there are others which treat such loss as an independent form of loss. He further submits that the expectation loss principle cannot provide a rational and sensible explanation for the award of damages in wasted expenditure cases. So that's an important submission made by Mr. Brenton in that case, which Mr. Justice Tier was going to have to deal with. He then refers to a number of authorities which have been identified by Mr. Brenton. And if we turn over a couple of pages, we get to paragraph 42. And incidentally, he relied on passages from McGregor and Chitty to support his position. At 42, Mr. Justice Tier said this: I consider that the weight of authorities strongly suggests that reliance losses are a species of expectation losses, that they are neither, to use Mr. Brenton's phrase, fundamentally different, nor awarded on a different juridical basis of claim. That they are a species of expectation losses is supported by the decision of the Court of Appeal in C&P Haulage and by very persuasive authorities in the United States, Canada and Australia. Mr. Brenton nevertheless invites me to prefer his submission because the expectation loss analysis does not provide a rational and sensible explanation for the award of damages in wasted expenditure cases. It seems to me that the expectation loss analysis does provide a rational and sensible explanation for the award of damages in wasted expenditure cases. The expenditure which is sought to be recovered is incurred in expectation that the contract will be performed. It therefore appears to me to be rational to have regard to the position that the claimant would have been in had the contract been performed. If there were an independent principle pursuant to which expenditure incurred in expectation of the performance of a contract was recoverable, without regard to what the position would have been in had the contract been performed, the defendant would in effect underwrite the claimant's decision to enter the contract. And then he talks a bit more about that. And the final sentence of that paragraph: the claimant's expenditure should only be recoverable where the likely gross profit would at least cover that expenditure. And he says that was the approach of Chief Justice Learned Hand in Armstrong Rubber and Mr. Justice Berger in the Boley logging case, and that was followed and approved in C&P Haulage. And at 47, the authorities therefore state a rational and sensible explanation for the view that the expectation loss principle underpins the award of damages in wasted expenditure cases. In some cases, a contract can be shown to be a bad bargain. In other cases, it may not be possible to show one way or the other whether the likely gross profits would at least equal the expenditure. In that latter type of case, the question arises as to which party should bear the evidential burden of proof. Should the burden be on the claimant to show that the likely profits would at least equal his expenditure, or on the defendant to show that the likely profits would not at least equal the claimant's expenditure? You'll note in both cases he refers to likely profits. The authorities to which I have referred, in particular Armstrong Rubber and CCC Films, provide a rational and sensible explanation for the view that that burden should be on the defendant. He then refers to further submissions made by Mr. Brenton, including Mr. Brenton's reliance on a passage in Tritle damages for breach of contract. And he says at 50, I am, however, naturally troubled that Professor Tritle suggests that an award of reliance damages appears to be inconsistent with the principle in Robinson and Harman, that he suspects that the suggestion that such an award is consistent with that principle is a verbal trick, and that there are in reality two different principles which are recognised by English law which cannot be welded into one. Those principles are, firstly, that an award of damages on an expectancy basis is designed to put the claimant in the position he would have been in had the contract been performed, and secondly, that an award of damages on a reliance basis, it is designed to put the claimant in the position he would have been in had the contract not been made. This is Mr. Brenton's argument. And then he talks about how Mr. Brenton illustrated it. And 52, he said this, the force of this criticism depends on what is meant by an election. The criticism assumes that the right to elect between a claim for expectation losses and a claim for reliance losses is a right to elect between two inconsistent remedies or courses of action. An example of such an election is where, following a repudiatory breach, the innocent party must elect between affirming a contract and accepting the breach as terminating a contract. If, however, all that is meant is that a claimant may choose to frame his claim for damages on the reliance basis rather than on the expectancy basis, as suggested by Mr. Justice Hutchison in the CCC Films case, with the defendant having the opportunity to prove that the expenditure sought to be recovered would not in any event have been recouped because, for example, the contract was a loss-making contract, then the right so to elect is not inconsistent with reliance losses being a form of expectation losses. And my lords, if one then goes on to 55, he said this, I am therefore not persuaded that the right to choose or elect between claiming damages on an expectancy basis or on a reliance basis indicates that there are two different principles at work. Both bases of damage are founded on and illustrations of the fundamental principle in Robinson and Harman for the reasons explained by Chief Justice Learned Hand and so on. Thus, notwithstanding my unfeigned respect for any opinion of Professor Tritle, I am unable to accept that there are two principles rather than one governing the law of damages for breach of contract. And then 56, which may be interesting in the light of Atos, Mr. Brenton has a further criticism, namely that there are many contracts where a party does not expect or aim to make a profit, such as where purchases are made for pleasure or for charitable purposes. He suggests that the expectancy basis would deny recovery of wasted expenditure in such cases. I disagree. In such cases, the defendant will usually be unable to show that the expenses exceeded the benefit expected to be obtained from the contract, and thus the expense will be recoverable as damages. This was recognised by Mr. Justice Dean in the Commonwealth of Australia case, and he sets out, quote, in relation to that. And then finally in this case, at paragraph 59, the judge said this at the third line, in circumstances where the reasons I have given, the weight of authority firmly suggests that an award of reliance damages is governed by the principle in Robinson and Harman, I consider that to award substantial damages measured by wasted expenditure, where the owners have as a result of the charter's breach been able to trade the vessel at the higher market rates and have more than recuperated their loss, would be wrong in principle. Such an award would place the owners in a better position they would have been had the contract been performed. Moreover, damages for breach of contract are intended to compensate the loss suffered. The owners have, as a result of their own efforts to mitigate their loss, suffered no loss, and so on. So, my lord, essentially, the point that is being made there is that wasted costs are recoverable as a proxy for the loss of bargain which a claimant, in this case a Cisco, expected to obtain. And indeed, my lord, it's not just me that says that. That is Cisco's own pleaded case. Can I show you that? It's in the core bundle, tab 15, page 346. This is an extract from Cisco's re-amended reply and defence to counterclaims, where in paragraph 55, responding to some points we had taken, they say at 55.2, second sentence, it is settled law that costs incurred in reliance upon a counterparty's performance of a contract and wasted as a result of the counterparty's repudiatory breach may be included in the wasted expenditure claimed as a proxy for the damages to which a claimant is entitled in order to put it in the position it would have been in had the contract been formed. So Cisco certainly then accepted that the correct approach is that which had been explained in OMAC. And as your Lordship has seen, OMAC it's been warmly approved, including by Mr. Justice Leggett as he then was in Yam Seng. And I do want to just return to Yam Seng, if I may. It's in the...
Can I just ask that? At the moment, I certainly don't understand that anything you've been doing now is contradicted by Mr. Thankey. It all seems to be common ground at the moment.
Well, my Lord, if that's right, then we need to look very carefully at some of the things Mr. Thankey says, both orally and in his skeleton, when he talks about reliance loss, because he comes very close to treating reliance loss as a separate and recoverable head of damages. And my Lord, I was going to come...
We always have to come back to remembering here that although we've plainly got to look at the interrelationship between expectation loss and wasted expenditure, at the end of the day, what we're looking at is what the meaning of an exclusion clause is.
Yes.
Whilst we can get very deeply into the academic analysis, at the end of the day, we've got to come back to what the words of clause.
Of course, my Lord, I fully intend to do that. But my Lords, in my submission, one needs to be careful not to put the horse before the cart. You first of all have to identify what is the loss for which the claim is being made. When you have properly identified that loss, you then go to the exclusion clause and you say, is that loss of a type that has been excluded? And that is why we submit it is so critical here to understand when one talks about reliance loss and wasted expenditure, that is not that those are not losses that stand alone and can be recovered alone. The only way in which those losses were going to be recovered was through recoupment, through savings, through revenues. As your Lordship can see clearly where I'm going to go with that when I come to the exclusion clause. And that's why it's critical not to fall into the trap, if I may put it that way, of thinking that reliance losses are somehow some sort of separate category. They're absolutely not. And, my Lords, can I just make good the point I made about the heresy? If one takes, just as an example, I was going to come back to it later, but just as an example, my learned friend's submissions core bundle, tab 2, page 23, where paragraph 37, my learned friends say this: clause 23 expressly excludes some, but not all types of loss of bargain damages. There's nothing surprising about that, we agree. Parties may be willing to permit claims for wasted expenditure or reprocurement costs, but not claims for loss of profit, revenue or savings. Like claims for wasted costs, claims for reprocurement costs are inherently capped, namely at the additional cost of implementing a substitute system. They're also easier to quantify and verify than loss of profit, revenue or savings. Cisco accordingly submits that it is perfectly coherent to exclude 3 types of loss of bargain damages, namely loss of profit, revenue and savings, which have no inherent caps and which are harder to quantify and verify, but not 2 other types namely wasted expenditure and re-procurement costs. Now, re-procurement costs is a separate type of claim which can properly be made because those are costs incurred as a result of the breach. But wasted expenditure is costs that would have been incurred in any event. It's therefore only recoverable under the heading of expectation loss, and therefore...
So re-procurement costs are expectation loss?
No, with respect, re-procurement costs are the costs of your supplier lets you down, you buy an alternative altogether, and so you then claim for that cost of re-procurement. They are separate costs which you have incurred as a result of the breach. They're entirely different costs which you would have incurred in any event under the contract. You wouldn't have incurred those re-procurement costs if, in our case...
But that's what you've lost. That's the loss of the bargain. You buy, if I buy a car for £10,000 and for whatever reason it's not delivered to me and I have to go and buy a replacement for 11,000, my damage is 1,000. That's the cost of re-procuring a car.
Yes.
And that's absolutely bog standard loss of bargain damages, isn't it?
But my lord, you're there. Exactly. But you're essentially claiming what you're doing is you're saying, I incurred re-procurement costs of 11,000, but I must give credit for the 10,000 that I was going to have to spend anyway, and that is why my loss is 1,000.
It comes down to the same thing because I can look at it in one of two ways. I had to say, look, I had a car. I bought a car for 10,000 and I had to go and buy one for 11, so I've lost £1,000. Or you can say, well, I would have got the car for 10,000 and I could have made a profit by reselling it at the market rate of 11,000. It doesn't matter which way you look at it, it's your loss from losing the bargain. That's what you've lost from not having had the car you bargained for. It's £1,000.
Yes. But my lord, with respect, that doesn't assist with the analysis we're concerned with here, which is this isn't the lost bargain here was they didn't get their IT system. What they're saying is, or what they have to say is, had we had our IT system, we would have recouped the expenditure which we've incurred. When you ask the obvious question, well, how would you?
Well, that's the leap.
But it's not a leap with respect.
Well, it is a leap. It is a leap. The lost bargain is not having the system, not having the IT system.
But
That's the just as it was in Atos, not having the system. As a result of that loss of bargain, they say, well, we've spent all this money and it's all been wasted because we don't have a new IT system.
But my lord, the logical end point of that approach is that it would never be open to a defendant to be able to establish that the wasted expenditure would not have been recovered. Because it's always a response to say, oh, but I didn't get my IT system. And yet the cases make it perfectly clear that if you as a defendant can show that actually the claimant wouldn't have recovered the expenditure which it was going to have to incur, in other words, it was a bad bargain, then the claimant can't recover for that wasted expenditure.
But that becomes, in fact, a causation point.
Well, it's an evidential
It's a
presumption.
causation point. Why has the cost been wasted? Is it because the contract wasn't performed, or is it because the contract was a bad bargain?
But, my lord, with great respect, this is the fallacy of the Peel article, actually, which we'll come on to in a moment.
Fallacy of?
The Peel, Professor Peel's article, which we'll deal with in a moment. But the starting point when you're looking at expenditure that has been incurred is that is not recoverable per se. And so in order to say it can be recovered, what the claimant has to say is, I entered into a contract which would have enabled me to recover that expenditure. Now, because of evidential difficulties, I am going to simply claim for that expenditure and leave it to you, Mr. Defendant, to prove that I wouldn't have recovered those sums. Burden falls onto you. That's the CCC Films approach. But, my lord, the fundamental underlying proposition is still that the claimant would have recouped his expenditure from the benefit, the bargain of the contract. And the benefit, the bargain of the contract here was, as the judge found, as a matter of fact, anticipated savings, increased revenue from increased premiums. And indeed, there's no leap, in my respectful submission, there's no leap to say, well, you've moved from wasted expenditure to recouping expenses. Wasted expenditure doesn't just exist as a concept. You have to say, well, how does the claimant recover that wasted expenditure? How is he entitled to recover that expenditure from the defendant? Answer, because he would have recouped it from his bargain. How would he have recouped it? From savings and increased revenue. And my lord, there's no wriggle room round that. The moment one accepts the fundamental underlying principles that are set out in OMAC, and the moment one accepts that it's simply so-called reliance loss is actually simply part of expectancy loss, and you have to therefore look at the expectancy, you are, we would submit, logically driven to that conclusion. Can I take your lordships though to Yam Singh, because I just want to highlight one aspect of the judgment of Mr. Justice Leggett as he then was. It's in the authorities bundle. It's behind tab 3, page 685.
Sorry, which, remind me, you said, but I missed it.
I'm so sorry.
Which authorities bundle?
Authorities bundle 3, tab 23. I don't think I did say it actually, I'm sorry. Tab 23, and it's page 685 I wanted to go to. Yes, my lord, the learned friend read to you, I think, the passages 186 onwards, and so I won't read those again, other than say they endorse, of course, what Mr. Justice Tier was saying. But if we pick it up at 190, having talked about rebuttable presumptions and so on, Mr. Justice Leggett said this: it seems to me that the rebuttable presumption that the claimant would have recouped expenditure incurred in reliance on the defendant's performance of the contract is an illustration of this approach. Parties in normal circumstances contract and incur expenditure in pursuance of their contract in the expectation of making a profit. Where money has been spent in that expectation, but the defendant's breach of contract has prevented that expectation from being put to the test, it is fair to assume that the claimant would have at least recouped its expenditure had the contract been performed, unless and to the extent that the defendant can prove otherwise. So, in effect, what Mr. Justice Leggett is there doing is summarising what I say is the correct position, which is that there is a rebuttable presumption of recoupment, and he situates that within the general approach of the law, which sometimes shifts the evidential burden where it's the breach that's made quantification and proof of a claimant's loss more difficult. And that's exactly what happens here. The burden shifts to the defendant because of the difficulties that the claimant has been put into. But the fundamental and underlying nature of the loss is the presumption that the claimant would have recouped the expenditure. Now, as your lordships are aware, Mrs. Justice O'Farrell considered all of these authorities in her judgment. It's paragraphs 670 to 678, before she then referred to her own previous decision in Atos, and perhaps we can look at that. My lords, it's in the authorities bundle, third authorities bundle, tab 19. Sorry, forgive me, I'm going to have to find a page number. Page 526 is where it starts. And sorry, got a bad reference in there. Yes, if we my lords, go forward to page, in our hard copy, 535, paragraph 53, which deals with where the judge dealt with legal principles. Now, as your lordships are aware, Atos was a similar claim to that made by Cisco, save for the all-important fact that the claimant was an NHS trust which did not expect a system which was being installed to result in a financial benefit. And that was something that was explained in the case itself. Sorry, if we move forward to page 536, paragraphs 60 through to 63, where the judge said the trust not entitled to recover as damages any lost profits that it anticipated it would make using the new system, nor any lost revenue or savings that it planned to generate from use of the system. These categories of loss are expressly excluded. However, that does not preclude the trust from recovering damages to compensate for the loss of a functioning EMR system. That was a contractual benefit to which the trust was entitled and of which it has been deprived by Atos's alleged breach. The rebuttable presumption that the value of that loss is at least equal to the trust's expenditure does not transform the claim for a loss of the EMR system into a claim for loss of any additional benefits that would flow from use of the EMR system. Atos's submissions wrongly assume that any contractual benefit which is presumed to at least equal the value of the expenditure must represent profits, revenues or savings. In most commercial cases, there would be such a defined financial benefit that would be expected to defray the costs incurred and render the bargain financially viable. However, that is not the case where the contractual benefit is non-pecuniary. In those cases, the anticipated benefit is not a financial gain that could defray the costs incurred, but rather a non-pecuniary benefit for which the claimant is prepared to incur such costs. In cases where a party does not expect to make a financial gain, it is the non-pecuniary benefit that is assigned a notional value equivalent to at least the amount of expenditure. And then she goes on to say, in this case, regardless of whether the EMR system was anticipated to produce any profits, revenue or savings, the trust would have had the use of the system as a contractual benefit. Claim for wasted expenditure is based on a rebuttable presumption, not that the EMR system would produce revenues to defray such expenditure, but rather that the use of the EMR system was worth at least the expenditure incurred. And then at 68, she refers to the burden of proof lying on the defendant, CCC films and so on. And she says, in the case of a contract where no financial gains were expected, the recoupment in question would not be payments but alternative gains such as use or enjoyment. To establish a bad bargain, in such a case, the defendant would have to show the value of the asset or other performance promised was less than the expenditure incurred by the claimant. My lord, this in a sense was a point that was slightly anticipated by Mr. Justice Tier in OMAC. We looked at it a moment ago, paragraph 56. As for the decision itself, we do suggest it can be justified on the particular facts of the case. But I don't have to go that far, frankly. I'm only here to defend the judge's decision in our case. The judge described the use of the EMR, the electronic medical record system, as a contractual benefit regardless of whether it was anticipated to produce any profits, revenue or savings. In that sense, her factual finding in that case is to be distinguished from her very clear factual findings in our case, where she found in terms that the benefits which Cisco was anticipating getting from the system which IBM was going to install was going to be anticipated savings and increased revenues.
What do you say in answer to the submission that means that the same or substantially the same clause could have a completely different meaning depending on the contract?
Well, my lord, because ultimately we are talking about factual questions. What is the loss? What is the nature of the loss? If the nature of the loss...
Well, just on the construction point.
Yes, but my lord...
How can an exclusion clause mean one thing in one contract and exclude wasted expenditure in one contract, but allow it in another because of the benefits?
Because
as a matter of construction.
Yes, because, my lord, the language excludes savings and revenue and profits.
as it did in Atos.
Indeed. If in one contract there are no savings, revenues or profits to be excluded, the benefit of the contract, the benefit of the bargain is a non-pecuniary benefit, then that clause doesn't bite. If, on the other hand, in our case, the benefit of the contract is financial, it is going to be savings and increased revenues, then one can see how the clause does apply. And that's why I say, although you can have the same language, you have to look at the underlying facts, which is what the judge did. I mean, it's actually quite extraordinary in a way that the same judge had to consider the language of this clause in two separate cases. But, my lord, I would say this. Actually, in some senses, Atos is a much more difficult case than our case, because our case is very straightforward. In our case, the only benefit that's identified by the judge, or the benefit that's identified by the judge that's going to come from our contract, is that of anticipated savings and increased revenues. The complications that had to be considered, or the complication that had to be considered in Atos, simply didn't arise in our case. And as I mentioned earlier, I'm not here, I don't have to defend Atos. In fact, I do suggest that Atos is right on its facts, but I'm sanguine.
I understand that, save that the judge, in her analysis, did distinguish Atos.
Well, she distinguished it on its facts. Absolutely. Yes.
She distinguished it on the non-pecuniary benefit point. So it does have some relevance to your, on this point, resistance of Mr. Thankey's appeal. But you address this by saying, well, here it is a financial benefit. So what you say, that what you describe as the Atos complication doesn't arise.
Precisely, my lord.
So going back to buying a car, so I go to a dealer to buy my car for £10,000. Now, I'm not going to use my car for business. I'm never going to make a profit from using the car or earning revenue from using the car. But somebody else who goes into the dealership may be going to use it in their business. The dealer won't care. They just want the £10,000 for the car. So when in their standard terms and conditions, they exclude liability for revenues, profits, or savings if for some reason the contract is breached. Is it your case that it means different things depending on whether the purchaser is a pure consumer like me or somebody who's buying it in the course of a business like a self-employed barrister?
Well, can I ask, in order to answer that question,
Yes.
what your lordship has in mind happens in that contract? Is it said that the car simply isn't delivered, or
The car is not delivered.
so if the car isn't delivered, then the remedy I would submit for both buyers, regardless of their particular attributes, is to buy a replacement car. I mean, that's sale of goods is perhaps not the best analogy to be using here, but
But let's imagine for some reason, let's say that either I or the person in business has incurred costs in and about the purchase. For example, travelling to look at it, possibly arranging a loan with their bank for which they've incurred fees, etc. So they have wasted expenditure, and they claim the wasted expenditure, saying, "Look, I can't go out and look at replacement cars, and it's difficult to assess how much this replacement for this second-hand car would be. I'm going to elect to choose my wasted expenditure." Why shouldn't he do that on Anglian Reed principles?
well, my lord, he might do, but the reason I suggest that it's not a good analogy is because with a car, it's a very replaceable commodity, and it's quite obvious that the remedy is you just go out and buy an alternative car. It either
Well,
costs
this is
more
where
or
I think,
less.
forgive me, I think your argument falls down, because there is a quite obvious remedy for a contract such as this, which is that you go out and you get somebody else to provide you with your IT system.
A completely recoverable remedy under this contract, subject to a cap of 150%. A completely recoverable remedy. 23.4 of the contract. And that's really important. It's important in my favour, not in my learned friend's favour, because we are not excluding costs of cure. So there is express provision for the
Why
replacement.
can't they have wasted expenditure in the alternative to that?
Because it's not a standard, because your lordship is, with great respect, falling into the heresy of treating wasted expenditure as if it's a separate, standalone head of damages which doesn't survive or doesn't exist other than as an expectancy loss. And the moment you accept the principle that it's an expectancy loss, you have to look at the expectancy. What is the expectancy? How is that money going to be recouped? And it was going to be recouped.
But as my law says to you, surely that then comes in. We see Mr. Justice Leggett and numerous other authorities saying the presumption is that it is, and it's then a matter for the defendant to establish, to rebut the presumption.
Absolutely, I don't have a problem with that. That's an evidential burden that shifts from.
But that doesn't mean that wasted expenditure is excluded.
No, of course not. But whether the wasted expenditure is then excluded then takes you back to the language of the clause. And the language of the clause, as we know, we'll look at it in more detail in due course, but the language of the clause excludes loss of savings and revenues. And if the true...
Not procurement costs.
No, not re-procurement costs. No, it expressly allows for re-procurement costs. But that is...
Well, why? Forgive me. The question is, why, in principle, cannot the party elect wasted expenditure rather than other recoverable expectation damages? And once you accept, I think you must, that wasted expenditure can be claimed in the alternative to loss of bargain damages, then they're recoverable. And then when you look at the clause, are those loss of bargain damages excluded? No, they're not.
No, my lord, with respect. The loss of bargain damages that the wasted expenditure claim, for which a wasted expenditure claim can be made, is nothing to do with re-procurement costs. That is because that's not, you haven't incurred your expenditure. Cisco didn't here incur its expenditure in the context of a re-procurement or a cure.
Nobody's suggesting that.
But your lordship is.
This is an alternative basis. This is what you've been showing us. That this is a wasted expenditure is not the loss of the same as the loss of profits or revenue or re-procurement costs, loss of bargain or whatever. It is another way of assessing that same measure. But it's not the same thing.
No, well, but it's recoverable. It is only recoverable on an assumption or a presumption that it could be recouped through revenue, savings and profits. And if that...
I really don't understand this at all.
Well,
there may be many cases in which there will be no revenue, savings or profits. That's in my example of where I bought the car for 10,000 and would have to spend another 11,000 to buy another one. There's no revenue, savings or profits there.
Well, Lord, I'm sorry. I don't think the car analogy, frankly, is apt to our discussion. But I'll look at it overnight and give it some further thought. But to say that the wasted expenditure is divorced in some way from the additional savings or the anticipated savings and the revenues, when actually it's only recoverable on an assumption that those additional savings and those revenues would have enabled Cisco to recoup that expenditure. You can't divorce the two in the way that your lordship seems to want to, because the moment you divorce the two, what you do is you end up treating reliance loss as a separate head of loss, which is exactly what all of the cases I've just been taking your lordship to says you cannot do. It's the heresy from the article in the 1930s, which my Lord Justice Coulson referred to, and it's described actually by Professor Burrows in his book as a myth. It's the myth that there is this separate head of reliance loss. There isn't. One needs to understand that you are enabled to claim sums as wasted expenditure on the sort of assumption that you would have been able to recover those sums as part of your bargain from the additional revenue and from the savings.
Unless you have a completely different contract when none of that applies. But the words can be exactly the same.
Yes, but my lord, we have to deal with our contract.
Well, that I follow. It's just that the consequences are as a matter of pure construction, which I know we keep saying we're going to get to, but that's what this is all about.
But then it's a question of getting back to what is the bargain, isn't it? Because if your lordship says, oh, but then you can
no. The starting point is clause 23.3. What does that mean?
But, well,
in accordance with Arnold, Britton, Woodspan, and everything. Then if it's suggested that it excludes wasted expenditure, then you look at the words, and then there's the question of, is it an exclusion clause? Then you come on to, if there are two competing interpretations, which you go for.
But my lord, with respect, how can you determine what the clause means until you know what it is, what the true character of the loss is that's being claimed by Cisco? Because you can only say, is this loss excluded?
They're claiming wasted expenditure. There's no dispute about that.
Well, but my lord, until you understand what that truly means, you can't then interpret the clause.
They're claiming wasted expenditure. They paid you 31 million for a system that doesn't work.
But my lord,
there's an item of wasted expenditure. That's what they're claiming.
Yes.
I don't need Professor anybody to tell me that, or to tell me what the juridical basis of it is. This is money they've wasted because the system never got delivered or never got properly delivered.
But my lord, you do need to understand with great respect why that is recoverable as a matter of contract damages, and not confuse it with damages for tortious remedies. You're not putting them in the position they would have been in if the contract had never been made.
No. Quite, that's the big difference.
Exactly.
I completely get that.
So you've got to put them in the position they would have been in if the contract had been performed.
Yeah.
If the contract had been performed, the logic is that expenditure would not have been wasted because it would have been recouped. It was going to be incurred in any event. Really important not to lose sight.
Going to be incurred in any event on the assumption that the contract was performed.
Precisely. And recouped.
But it wasn't.
And recouped on the basis that the contract was performed.
Well, that's part of the submission. I understand.
Yes.
That.
Well, I'm conscious of the fact I'm repeating myself.
No. It's just testing. It's simply testing where the submission goes.
Yes.
I hope we haven't interrupted you too much.
No, my lord.
I'm very sorry, Mr. Toddy, but I have just one further angle to throw in on this.
You've had my lord, you've had me.
Yes, it's only fair.
I think that's only fair.
You've been resisting the idea that wasted expenditure can be a proxy for lost bargain in relation to the reprocurement costs, because you say that's not a lost bargain measure. I hear what you say on that. What about a different way of looking at the loss? Based upon the way Mrs. Justice Zacaroli put it in the Atos case, which is, well, you've lost the system. You were promised a system. You haven't got that system. That system in the hands of Cisco had a value. It may well, you might say, before that system, it had a business with an agent system, which was worth X. With the benefit of that system, it was worth more than X. Now, why isn't that the loss in having that benefit, that increased value of a system, or indeed increased value to its business, not a loss that's recoverable under the contract, and one which is properly regarded as expectation loss, and therefore wasted expenditure is a proxy for that?
Yes. Well, first of all, you need some evidence about that,
and would you? It's a theoretical point, isn't it? Whether how you measure the loss.
Well, but and then I was going to go on to say this. The logic of where that takes you, if you're not careful, is that you effectively will say reliance loss is always recoverable. Because it was always my expectation I was going to have something. I was going to have, doesn't matter what it is, I was going to have a car, I was going to have whatever it is, I was going to have a system. And I spent all this money on that system, and I haven't got one, so now I ought to be able to recover that money. And that is...
That wasn't quite the example. The example was that with the system, you have something of real value to you. You might be able to sell it. You might be able to sell your business with the benefit of it, which was one of the options, I think, on the facts.
Yes, but my lord, if you're going to say that, then it's again, isn't it? It only has a value only has a value if it's going to produce additional revenue or it's going to save you money. That's the whole point. I mean, institutions like Cisco, insurance companies, don't invest in IT systems so they can have a pretty little system in their office. They do it for, and there was plenty of evidence for the judges, commercial reasons. It was to make money. It was to make them more efficient, and it was to increase their revenues. That was the whole raison d'etre for them of getting this system. And to somehow fudge that by saying, oh yes, but they've had a swanky system, it all would have been lovely and hunky-dory, is not really to address, under the law of damages, in my submission, what the true loss is. The loss to them is the loss of having that system which they thought was going to enable them to recoup all their expenditure and lead them to get the profit. And if one looks at the cases on wasted expenditure, where the courts recognise that defendants can challenge the claim for wasted expenditure by showing that actually the bargain was a bad bargain, they all work on the presupposition that you are able to show that actually the benefit, the financial benefit that the claimant thought it was going to get from whatever the product was that it was buying, or the service and so on, wasn't going to be as good as it had hoped. It was a bad bargain, and it wouldn't in fact have recouped all of its expenditure. And the law in numerous cases recognises that if the defendant can prove it, that is the claimant's loss will be diminished by that respect. And that actually in a sense ties into the questions I was being asked by both Justice Phillips and Justice Coulson, which is how does that right in a defendant to challenge what was going to be recouped, how does that right to challenge what was going to be recouped fit in with an analysis that just says, oh, well, I've wasted my expenditure? The whole point about the right to challenge the recoupment is exactly that. It recognises that it's about recoupment of expenditure through savings and through increased revenues. Now, my Lord, sorry, my Lord, shall I pause in case?
No. That's,
Right.
I think that's fine for now. You said that once you dealt with what you wanted to say on this bit, you were going to get Mr. Kramer to deal with the academic points.
Yes. My Lord, I haven't finished yet because I haven't actually, as your Lordship rightly rebuked me earlier, in fact, gone to the clause itself.
Well, it wasn't a rebuke. It was just that we had to keep reminding ourselves that it's a construction point.
Yes.
I mean, I think obviously this is the main point, and that was obviously the point that Mr. Thankey spent the longest on out of the five. So there's not a difficulty. How long do you think you're going to be, or before you would hand over to Mr. Kramer, which obviously would be tomorrow? Because
yes.
if you've got quite a bit to do, we may pause there and come back at 10:30.
Yes. Sorry, could your Lordship just let me have a
Of course.
So, my Lord, just to give you an outline, I think I've probably said what I want to say about Atos. I need to take you to a case called Data Liner. It shouldn't take too long. I then want to go back to the judgment and just say something about the way the judge approached the case. And then I want to talk about the clause itself and how that fits into the scheme of the contract. And then I need to deal with some arguments raised by my learned friends. So I have still got a bit of a way to go, yes.
Yes, okay. All right, well, but you're still, because you obviously started earlier, so you're
Yes.
still reasonably ahead of the
I hope so. My Lord, I am mindful of the time pressures. My Lord, I'll revisit my notes, obviously, overnight.
Yes. Well, if it makes any difference to the parties, can I indicate that we will be likely reserving our judgment so that the time that you will have otherwise allowed us for our extempore judgments at the end of the hearing, we will not require. So you can have that float.
Oh, my Lord, I'm very grateful.
All right, well, we'll come back at 10:30. Thank you both very much.
You'll be locking up.